a rape did not occur, making sense.
Makes a lot of sense. And my overall impression just watching this witness testify is that I have no idea what happened. Was it consensual? Right. Was it non-consensual? Who knows? Can bruising take place during consensual sex? Once lubrication then is inserted and you're having sex with lubrication, can that aggravate prior bruising? It's very confusing. That is beneficial to the defense for the most part.
That's a good thing, right? Because essentially if the jurors are confused, it's reasonable doubt.
That's true, except when you have this overwhelming picture and impression that the jury might have concerning the injuries themselves, and that's what you're fighting against.
Right. Now, one thing he did mention was that she bit herself on the arm, and that was interesting. I mean, that creates a scenario that suggests why wasn't she biting him, for instance?
That is one scenario, and that's really something that jumped into my mind when I was first reading the facts in this case. She said that she was so inebriated that she was helpless to do anything, and yet she was able to, bite her own arm. So that is something the defense may be able to use. The other issue, the way the prosecution can use that, is that, look, she's in a situation where she knows something horrible is going to happen to her. So she moves into the submission mode, and becoming passive and submissive in that situation would cause her not to act out against her attacker, but to choose to do whatever it took to not scream because she thought something worse could happen to her. I don't know if that makes sense given how close everyone lives together and given the nature of the relationships of the people within the university community, but that's certainly something the prosecution can argue.
Yeah, one of the unfortunate things, Rob, about rape cases is that often we have to put the actions of the alleged victim under a microscope, and it's so hard to say how someone's going to react when they're being traumatized in some way, so it often feels unfair, but defense attorneys have to do it. You have to go piece by piece and look at her actions. Now, but one of the questions for a defense attorney is how far do you go? Because you don't want to offend jurors in that way, but you do have to do it.
You need to get to the essence of your case. The essence of your case here is that your client did not do anything wrong and that this was consensual. One of the ways of showing that it was consensual is by showing that the woman has not consistently told the truth. And the pattern of her lying starts immediately, well, almost immediately, when she speaks to the police. It continues in her speaking with the nurse. It continues to a point well beyond that, when she's actually under oath and testifying before a grand jury, where she continues to either cover up for a legitimate reason, if you can say you perjure yourself for a legitimate reason, or she's covering up because she doesn't want anyone to ever know what actually happened in that room. The general rule is that you can attack a witness as long as you have permission from the jury. And it tends to be that once a jury sees that a complainant, no matter how sympathetic, has told a bold lie, and you're able to show that your client is the person who's being hurt by that lie and being denied justice because of that lie, you have a little bit of permission. Then as you expand that, you're able to go to greater lengths to show that she has not been truthful.
Yeah, but how far can you go as far as talking about these lies? I mean, again, is there a danger of alienating a jury when you have a victim who certainly, whether it was consensual sex or not, ultimately it was a traumatic event for that individual. So how far do you really have to be careful about crossing that line?
You can go all the way with this if you do it the right way. One of the things that Mr. Marlowe did in his opening statement was he began to prepare the jury for what he was going to do during the trial, something that might be unseemly to some without adequate preparation. What he was telling them was that this is a woman who will be sympathetic to you, she will look like she's telling you the truth, but she has a problem with the truth. And I am going to do everything in my power to bring you the truth, even if it means hurting her. You have to prepare the jury for it, but you're not doing your job if you're afraid to go after her. It's a matter of, like my mother used to say, it's not what you say, it's how you say it.
It's how you say it. There you go. You know, one of the interesting tactical issues in this case for the defense is whether, of course, they're going to make their client take the stand. And, of course, this oftentimes rape is a he said, she said, because the only people in the room are the two people involved. But this is a case, because of the background of the defendant, that we might not ever see him take the stand. In this particular instance, there is a prior sexual assault of some kind in the background of the defendant, but you don't want to put him on the stand because if that comes out, that could be the death knell.
That could absolutely wreck the case from the defense. And the danger that you have as a criminal defense attorney putting your client on the stand is that at this point of the trial, before they make a decision about what they're doing, it's all about the government's case. It's all about taking shots at the government's case, and you talk about what the burden of proof is, and the government has this overwhelming burden. When you decide to put your client on the stand, the jury tends to overlook problems in the prosecution case, and they tend to say, here's her story, here's his story, which do we believe? And all of a sudden, proof beyond a reasonable doubt, no matter what any juror tells you, is out the window, because if they believe her story is more likely than his, they will convict him.
But Rob, if he doesn't take the stand, is that something that's really terrible? Because again, we're going to be looking at a he said, she said without this guy taking the stand, let's say, and without hearing his story, is a jury more likely to say, well, he must have something to hide?
Well, the first thing is that apparently the judge has ruled that the defense will be able to get the defendant's story before the jury without having to be cross-examined, because he spoke to the police, and apparently they're going to be able to get that before the jury. But in normal cases, your point is well taken. Jurors are concerned. They're people, and they're wondering, if this guy is so innocent, if he did nothing wrong, why wouldn't he stand before us and tell his story? What you need to do is you need to prepare the jury, starting in voir dire, for getting reasons from them. Why would a person who's accused of a crime not testify? Can you explain to me why a person who does not speak particularly well might not want to testify before a jury? Other reasons. Or do you think it's just because they're hiding something? That helps you get your message to the jury concerning an important part of your case. It also helps you get information back from the jurors and strike these people, because if there are people saying anyone who's innocent would testify, period, that probably is not a person you want on your jury.
Absolutely not. And, you know, we always, the jurors are always admonished not to hold it against the defendant if he decides not to testify, but I'm not sure they all can do that.
Sometimes it is a reminder that is not welcome from the defense, because it's almost like the judge saying, now, before we get into the meat of this case, he's not going to testify, he's not going to testify, don't hold it against him. So I'm going to remind you, he's not going to testify, don't hold it against him, and it can hurt you.
It can hurt you. Well, Rob, I want to thank you for being with me this morning. Our time is up. As always, it was a great pleasure. I hope you'll come back and join me again sometime in the morning. It's always fun to have you here. Well, that's going to do it for me right now. I want you to stay tuned, because the lovely June Grasso will be in the anchor chair to take you through the rest of the afternoon. Now, one quick program note before I go. Crier today coming up at 1 o'clock Eastern Time. Catherine will have an update on the Diallo trial, and she will be joined by Diallo's father, who will give his impressions of the case thus far. And also, she'll have a report on the New Hampshire primaries. There were some surprising early results. Catherine will be joined by political analysts Michael Reagan and Pat Schroeder as they try to make hay out of what's going on in the race for the presidency. That's Crier today at 1 p.m. Eastern Time, right here on Court TV. Take care.